Today, I want to react to a video someone sent me of Ben Mallah, who's a real estate investor, on the Iced Coffee Hour with Graham Stephan.
What's the most expensive eviction you've ever been through?
Oh my God. They were all pretty much the same. You know, what happened, the reason why I got out of California was every time I had to do an eviction, even on criminals with police reports, that owed me money.
I want to stop and make a comment. Sometimes a lot of landlords I see complain about California, and I just have to congratulate Ben Mallah for leaving, because from my viewpoint is, if you don't like it, then you're free to sell your properties and invest your money outside of California. I think a lot of investors do invest in California because California offers benefits to landlords like high rent amount and appreciation in their property value.
The fucking courts were so liberal in California. They all run the legal aid, whatever they called it, you know. And then those fucking people, they all went to school in Berkeley, and then they go work in San Francisco and want to save all the people that don't give a fuck about nobody but themselves.
I think the legal aid organizations that he's talking about, even the playing field, because from my experience in the unlawful detainer courts, I'd probably say 90 to 95% of all landlords come in with an attorney, and that in the counties like Solano County, for instance, that doesn't have these legal aid organizations assisting tenants, the tenants have no shot against the landlord's attorney, and that the legal aid attorneys, whether it's the Oakland Eviction Defense Center or Central Legal or the San Francisco Eviction Defense Center or Bay Area Legal Aid, in my viewpoint, they even the playing field. So if a landlord has a situation where a tenant hasn't paid rent and the tenant doesn't have any defenses to that, the landlord is going to win the case. It's just a matter of time. But from what I see, a lot of times tenants do have defenses, and because they're represented by these organizations, they'll be able to be on an equal playing field with the landlord and their attorney.
Those are the people they want to save. Listen, if a poor person needs help and they're a decent person and they need help, I'm all for it. But they want to go beyond that. They want to save the fucking poor people that are fuck-ups and criminals. And that's what they did to me in California, okay?
What happened?
Every fucking time I want to evict somebody, right away, we request a jury trial.
It's every tenant's right, a legal right to request a jury trial. They're entitled to that. I don't understand why Ben Mallah and other landlords in California complain about this fact. It is their legal right to request a jury trial, and it's just part of the process.
You know what that means? It means I got to pay my lawyer $5 or $10 grand for a fucking tenant that owes me a grand and get him out of my place. Nobody goes to jury trial. But that's your way of sticking your landlord in the corner and making him settle. Well, give him 3 months free, pay him $2,000 for moving.
Here's the thing. No one's forcing anyone to settle, landlord or the tenant. And from the landlord's position, if you don't want to settle out with your tenant, you can take it to trial. And so he can't have his cake and eat it too. In one sense, he's complaining about having to enter into a settlement in an unlawful detainer. And then the other hand, he's complaining about the attorney's fees. If you don't go to trial, usually the attorney's fees for the unlawful detainer attorneys, they charge a flat fee, generally speaking. And so you only have to pay more if you go to trial. But if you settle, you're essentially going to pay the same, from my viewpoint. You go to trial, you may pay tens of thousands of dollars in attorney's fees. You settle, you pay your attorney fee a flat fee plus whatever the settlement is. And keep in mind that, from my understanding, Ben Mallah, when he was here in California, all of his tenants were Section 8 tenants. That was like his specialty. That was his niche. He had a bunch of apartment buildings in East Oakland, and he rented to Section 8 tenants. Section 8 tenants usually pay a small portion or a portion of their income, but they generally tend to be tenants who have lower incomes. So the housing authority will pay the bulk of their rent. So if someone's rent is $2,000, the housing authority may pay $1,500 of that, and the tenant is responsible for $500. But keep this in mind. When a Section 8 tenant files an unlawful detainer, that's the legal word for eviction, when they file their unlawful detainer against the tenant, Section 8 continues to pay their rent. So in this case, Ben Mallah is not completely out of luck. He can't accept rent from the tenant, but he can continue to accept rent from Section 8. And this is completely different than non-Section 8 landlords who legally cannot continue to accept rent once they file an unlawful detainer, or once the 3-day notice expires.
Fees and the loss of rents and that money I had to even pay them to get the fuck out could be like at least 5 to 10 grand. Now it's probably, who knows, even more. 15, 20, I don't know. The politics there was so bad. The courts were just so one-sided.
Again, I hate when landlords complain that the unlawful detainer system in California is one-sided. In my opinion, it's completely, to me, it's fair. If anything, it's one-sided in favor of the landlords. One, in a normal civil case, you have 30 days to respond to the lawsuit after you've been served. In an unlawful detainer trial, or in an unlawful detainer litigation, you have 5 court days to respond. 5, that's it. So let's say you happen to be out of town, you get served with a lawsuit or with an unlawful detainer, you have 5 days to respond. And then the landlord can take a default against you. The discovery process is extremely fast, and with an unlawful detainer, you have 5 days to respond to written discovery requests. Versus in a normal lawsuit, you have 30 days to respond. And generally speaking, even though jury trials will delay the trials in comparison to a court trial in an unlawful detainer, you're still going to trial in 2, 3, 4 months after the initial filing. Versus in a normal lawsuit, I have trials 2.5 years away for cases that we filed 6, 7 months ago. So to get to trial in a normal civil lawsuit, at least in Alameda County, and that's what Ben Mallah is talking about, is sometimes 2 to 3 years depending on what department you're in. So when landlords complain, oh, we have to wait 3 to 4 months, that's weak, because if it was a normal lawsuit, they would have to wait years, and it literally cannot go any faster. And if they wanted to go faster, they should be complaining to the state of California, trying to get more judges so we can have dedicated unlawful detainer judges to make it go faster. But even then it's still not going to go much faster than 2 to 3 months, in my opinion. So look, and my reaction generally to these talking points that landlords bring up is that, man, if you don't like it, leave. And that's what appears that Ben Mallah did. Other states, to me, are extremely one-sided in favor of the landlord. Here in the Bay Area and Alameda County in particular, the organizations are just evening the playing field. Just because a tenant has a lawyer doesn't mean that the tenant's going to win the case, but at least they have a shot. And I don't understand why landlords complain about tenants having representation so that they can enforce their rights and essentially even the playing field. When you go to other states, even other counties in California, it's 100% completely one-sided in the landlord's favor. And that's not even getting into the power dynamics where, again, Ben Mallah was a Section 8 landlord here in this county, and his resources are infinitely greater than all of his Section 8 tenants. And even his resources are greater than his tenants with the local organization. But at least the local organizations gave his tenants an opportunity to have their day in court, because Ben Mallah calling a tenant a criminal is not enough, right? If the criminal was in prison or jail, it would be an uncontested unlawful detainer. His allegations that they're criminals needs to be adjudicated in court, and that they're entitled to representation and a jury trial just like other tenants, in my opinion. So those are my thoughts. My office does not handle unlawful detainers, but we do handle affirmative lawsuits against landlords who violate habitability laws or some way harassing you, illegal payment of rent, for instance. And if you have those issues, visit our website, fightslumlords.com. I appreciate your time. I appreciate you watching this far and the reaction. Thank you so much. Bye.